Wadara consults educational videos. At Wadara, we produce educational videos for professionals writing qualifying examinations, CIN, that is insurance, CIPM, Chartered Institute of Personnel Management of Nigeria, and project management. Prince 2 to be precise. Please do well to like our video after watching, and also subscribe to our YouTube channels by clicking the subscribe buttons. This will enable you access more of our videos and preceding videos that have been recorded. Please do well to share your comments, your area of divergence, questions that you may want us to solve at the end of the video. After watching the video, please, in the comment section on YouTube, we will do well to respond, address area of concerns, and if there are observations, comments to be made on our videos, please do well. Insurance law. For proper understanding of the subjects of the course, it is important to know what common law refers to, because that would give us chronically the historical background into insurance law itself. Common law is a body of law composed of decisions made by judges in the past and used as an example in similar future cases. Common law also refers to the unified system of law developed from legal customs of the country, which was built in medieval times and was or less complete by 1300. Common law was the earlier form of law in England. The judges in different localities made judgments, and those judgments became binding on other similar future cases. That is why common law arises. Common law arises as a precedent. From this explanation, you will understand clearly the earliest decision I gave on common law. That is, it emanated out of decisions made by judges in the past and used as example in similar future cases. That is where the power that was bestowed on common law being the precedents emanated from. In cases where the parties, example, disagree, if two parties disagree on what the law is, common law looks to past presidential decisions made by who? The judges. In relevant courts, and synthesizes, that is, combine the principles of those past cases as applicable to the current facts, that is, the case at hand. That is just a broad understanding of how common law came to be. There is no way you will talk about common law without referencing England, the United Kingdom. More so, it is an unwritten law. These are attributes of common law as a whole, that is, to those parts of the law which are contained in decision of the court, that is now the case law, rather than statute law. Here we make reference to Act of Parliament and written rules and regulations. Because common law was rigid, and some will even say it was somewhat callous in nature. Ash, let's say ash, it was ash. Ash will precisely describe common law as against the callous. Equity subsequently came as supplementary systems of rules and principles which were originally developed and applied in separate courts. The Court of Chancery is one in this regard. And common law, the maxims of common law are the maxims of equity, I beg your pardon, equity. The maxims of equity acts. 1. Equity acts in personam. 2. Equity acts on the conscience. Equity aids vigilance. Equity will not suffer a wrong without a remedy. That is, equity will not allow a person whom it considers as having a good claim to be denied the right to sue. This is why, one of the reasons why this discussion around equity and common law are significant to the insurance law itself. Now we move to the Adjudicator Act of 1873 and 1875, from 1873 to 1875, which changes the administration of common law and equity. The common law courts and courts of equity were amalgamated into a single system. That is, they were combined. Into a single system in 1873 to 1875. This is a question you should note for examination. Here we talk about the principles derived from equity are Promissory Estoppels. Promissory Estoppel. Before we talk about it, let's talk about Estoppel first. This is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said or agreed by law. It is meant to prevent people from being unjustly wronged by the inconsistencies of another person's words or action. That is just about Estoppel. We now talk about Promissory Estoppel. Is a doctrine in contract law. A doctrine in contracts law, which enforces a promise, whether executed or a contract, whether executed as a contract or not. It enforces a promise, whether executed as a contract or not. It seeks to protect the right of a promise or aggrieved party against the promisor. That is all about the summary about this, the first principle of equity. Then we have injunction. In injunction is a court order. A court order. A court order requiring a person to do or cease doing a specific action. Requiring a person to do something or cease doing a specific action. This is C. Subrogation and contributions are one of the core principles of insurance, which we intend to discuss as we move on in the discourse on insurance law.